all this work. And the amazing thing is, Sandy just mentioned how they did some work on a sort of a customary court, an old Irish court here years ago. But the person who did it was a person called McMurrough, who was a colleague of mine. She was a year ahead of me in law school in Galway, and but we studied together. We shared an office one time for exams and whatever. And I know growing over the years, and I'm really looking forward to meeting up with her again. And it's a delight to me that she's there and she's in this, because what's amazed me is I spent about 20 years. I nationalized Peruvian. I worked a long time with indigenous peoples in the Amazon, and then I worked on indigenous peoples' traditional knowledge issues around the world. And when I was writing my book, it suddenly, it sort of came to me that I'd spent years studying indigenous peoples' legal regimes and customary legal regimes, and I had spent 7 years studying law in Ireland, and never once in my studies in Ireland was it brought to my attention about early Irish law. And so I had to go away for 20 years to get this feedback into early Irish law. We commonly tend to term it Brehon law. In reality, that is not the term that will be used by the body of law, which we refer to as Brehon law. It's called that because it was applied by judges named, I'm terrible with the pronunciation, but Brehuan or Brehons. The more appropriate term is actually Fenachas, and that's defined as the law of the Fenia or the free men, so customary, traditional, or native law. And then what was written law, and much of it was developed by the church, was known as Cain law. Now, before I go into that, and I just want to sort of go back and sort of saying what are the sources of law, and this was a significant part of the research that I was doing, because I was finding this challenge that we've been dominated for many years by what's known as positive law. In other words, the law which comes down from the government, it comes from above, and it's stipulated law. But if we go back into ancient history, before there was stipulated law, there was what we would know, there was two branches of law, really, basically. The first would have been customary law. It's the actual practices that people were dealing with in very early times. There had to be some sort of situation or control with regards to people killing one another or taking one another's food or doing things. And so they had to work out various systems. And if men were the hunters, there had to be a practice as well for ensuring that people would get fed, and there had to be distribution of food, etc. So going back to the earliest times, we had legal systems as they evolved, and they would evolve to sort of some forms of customary law. The Romans and the Greeks, they recognized three sources of law. There was natural law, which was sort of, it was the law that seemed to evolve out of people's practices, but more at a higher level, and it would be recognized through different cultures and tribes, etc. So they would have this kind of law that might be respected. Then they had custom, local, oral-based systems, and they would be more localized. But these customs that came up, they were the practices that people knew in the family, in the local tribe, in the clan, whatever. Positive law is a later development. It's the kind of written law. Customary law is only, like any kind of law, it's only as good as the preparedness of those who are governed by the law to accept it. So we have many laws which people don't follow, and which the state does not actually implement on a consistent basis. Laws can get adopted, and if they fail to be implemented or implemented, they'll be changed. Customary law was very much the same. Communities and large tracts of the world are people who are living under their own customary laws. They don't really recognize national laws. National laws may come in and impede upon them from time to time, but a lot of their decision making will be based upon their own customary legal practices. In medieval Europe, between the 9th and the 11th century, customary law was the primary basis of law. And so you would have different customary laws in different cities. And those local laws were the ones which governed. It was only towards the end of the Middle Ages that they began these processes of codification. And what was actually happening was a lot of these customary legal regimes were now being run by little despots. They've been tall despots as well, but there was a local elites, and may have been leading to lots of abuse. There would also have been situations where, any sovereign or any power that was trying to consolidate national power would be trying to bring a system which would ensure that they could control some of the local laws. And so the codification began. Now, what we have then is we have these tensions between customary law and this positive law. And natural law used to play the role of helping to resolve those conflicts. That if the customary law, the practice of the people, and the law being imposed by the superior power was in conflict, natural law was sort of the place where that might get resolved. Along the way, the church appropriated natural law, and it started to be coming to refer to it as canon law. And so we then have this situation where it's gone from a law which might have been recognized by many different creeds, and just it would be the practices. For instance, you don't kill ambassadors. That would have been a one which Muslim, Catholic, and other, or Christian and other religious groups would have recognized, in Chinese, whatever, for a long time. You have to have this ability so that you can come from one power group to another power group without the threat of murder. Ireland, the interesting thing about the Irish law, when I came to suddenly look into it, is that early Irish law was still in play up until the 17th century. That made it the longest surviving body of customary law in Europe. And, even after, and when we get on this at later stages, even up until the present day, early Irish law can, in some cases, still have a role to play in the legal system, although it's been seriously ignored. Now, there's a very, very well-known book. It's about the traditions, different legal traditions in the world, by a fellow called Patrick Glenn, and he talks about what he calls Teutonic law, Teutonic tradition, and he says it's the oldest legal tradition. All humans are descended from Teutonic peoples. And Teutonic peoples are those people who are like sort of very close to the land, very close to the earth. They're oral legal systems, they lack complex legal institutions, and they emerge gradually rather than in response to a particular event. And so they tend to subsist over a long period of time. There's many, many different traditions, and it's kind of linked in with other beliefs. So the law is not separate from morals or religion, though it has its own place. Interestingly, he talks about the lack of complex legal institutions. Ireland is one of the places in which a very strong legal system was developed with its own legal practitioners in the form of the Brehons, both as judges and as lawyers to seek to bring about resolution of conflicts. Now, Sandy mentioned the thing about the issue of this distinction between retributive and restorative justice. I won't go into that, but I thought, as I was looking through these various legal regimes for a long time, one of the most impactful moments was when I came across a book written by a person who is a Navajo judge. He was a judge of the Navajo Supreme Court, and Navajo himself. And he wrote a book about Navajo's ways, laws, and courts. And he talked about he talked about the principles underlying their legal regime. And what he talked about was, there was one term he used, which was Hosho. Now, my pronunciation is, I'm sure, very, very, very wrong, but it was Hozho, something like this. And this principle, it was a principle of harmony. And so the community was within the law when the community was in harmony. When there was disharmony, it was outside the law. And so the role of the law was to bring the community back to harmony. And, that seems to me like sort of, a really, really powerful principle. So we can say about customary law, it's primarily oral and uncodified. It's considered binding by those who are subject to it. It's dynamic, it evolves over time. When you write it down, you start to fossilize it. And that's an issue like with regards to early Irish law, because it's at the time at which it was written down and codified, and it was brought together by, with the, what do they say, three kings, three poets, and three priests. And here you have the kings as the rulers, you have the poets as the lawyers. It was very interesting to me. I mean, I remember my father used to tell me the story of Finn McCool and the Fianna, and how they had these very major tests to practice, to go through, to be warriors, running through the forest and ducking under a branch at the level of the knee without losing speed, and jumping over a branch at the level of the chest, etc., etc., and then being in a pit with 12 warriors throwing spears at them, or sharpened sticks, and if they get a scratch, they lose out. But what I couldn't understand was, what was the point of the 12 books of law? Or sorry, 12 books of poetry. Why were they learning these 12 books of poetry? And it was when I was studying a legal book written by a Ashinabek lawyer from North America. And he was pointing out that the source of the law is in the stories, and it's in the poetry and the songs, and it's in the dances. And then it became obvious, of course, where else would you have it? If you don't have a written system of law, you have to have a form of passing it on, and it has to be a form of passing it on that people will remember. And they're going to remember poetry, they're going to remember the stories. And so it becomes interesting to looking back and remembering that the importance of the poets. In Ireland, you would think that they had this very, very high level of respect. It wasn't just for the poetry; it was because these were the people who brought the sources of the law, and were therefore, very much sought after. It seeks to bring. It's tradition based, but it is open to new interpretations. So we have to think about customary law like constitutional law. Our constitution is not written in stone. Now, to go off the subject, we know that they're trying to put somebody into, a Supreme Court across the water who believes that it was written, that the Constitution must be interpreted at the time it was written. But of course, we understand the Constitution as being a living document. And I like to think about customary law as being living law. And constitutions and customary law, they're very, very similar. What's very interesting as well, just in this, is like that, people start saying, oh, well, it's not written down. It's not a full body of law. An awful lot of law is not written down. A lot of law is custom. A lot of international law, especially international commercial law, actually comes out of custom. And so, it is a very, very important part of the legal system. Now, in my perception, what's actually happened is we have this situation where we've been dominated by positive law for the last few hundred years, and it's like they cut off the legs of a three-legged stool. They lost natural law and they marginalized customary law, and that, I believe, has been responsible for the sort of a lot to do with our collapse in economic collapse, political collapse, and our environmental woes that we're sharing. And so it's not, when we talk about this, we must not be thinking that this is something sort of, oh, this is a very interesting historical thing. I don't approach this as a historical thing at all. I approach this from the perspective of decolonization of the legal system. And I have watched how in other countries, in Papua New Guinea and other places, customary law has been given and recognized as having the same status as common law, the inherited common law. So if you have a conflict between common law and customary law in many of these countries, customary law will actually, in some cases, be given the upper hand. What we did here, we actually had this, customary law carried on here until the 17th century. And its demise came with two particular cases that were brought during the times of Charles I. And the two cases were, one of them was where they did away with gavel kind. Now, gavel kind obviously was one of these things that led to that system, which is complete breakdown of land. And here on Clare Island, of course, when the congested district boards, they after the famine, they came here, and there was the population was just too large for the land, and they divided up the land in a new way, and the stripes, whatever. But the gavel kind, interestingly, Janelle sort of says, although it was, it led to this breakdown, what it did mean is it meant that like every member had some start, some little start to go forward. So gavel kind was one thing they got rid of, and they got rid of it as well. I mean, they didn't get rid of gavel kind because of wanting to improve necessarily the lot of the poor. They got rid of gavel kind because you can't get much in the way of taxes out of gavel kind, and so they wanted to consolidate greater lands, and they wanted systems which would be more productive for returns to the landowners and of course to the kings. The other case was the case, the Tanistry case, and basically what it was they attacked the system of the Taoiseach system, which would allow for the most appropriate and able leader to take power, basically, on the demise of the current ruler. And it's interesting, the English said that it was because it was a sort of a barbaric system. As we look back at their own history in primogeniture, it doesn't appear to have been any less conflicted. And the history of the deposing of rightful heirs under their own system was not stopped by some superior system. What it was really, and this is the real challenge, and this is why the English really wanted to break this system, is when the English came and started to take over and take lands here, they expected that the English lords who were given lands in Ireland would follow the common law system. What actually happened was they very quickly moved over and followed the Irish legal system. And so it wasn't until the Tanistry case that it started to break down. Now I think I've been going for nearly 20 minutes, and I want to finish up for this initial session. What I'm going to do in the second session is I'm actually going to go and I'm going to talk to 3 specific aspects of early Irish law in which we can see fundamental human rights. And I want to do it in terms of showing its importance and to give a little more knowledge of where it's taken to us. But I wanted to just say, in 1920, what were called the Dáil courts, or the Sinn Féin courts, also called Republican courts, they started to apply a mixture of Napoleonic law, Roman law, and early Irish law. And at the time of the Constitution in 1937, the framers of the Constitution, there was a number of members there who had hoped they brought in various principles in relation to land rights and women's rights and others, which were coming back from principles that they were drawing from early Irish law. Not all of them made it into the Constitution. And the Sinn Féin courts ran until, with the Civil War, the government, the Treaty Party, they declared the Sinn Féin courts no longer valid, and they took up the common law system and used that to concentrate their power. It seems a pity. We might have decolonized our legal system at that time, but we still haven't achieved it yet. Now, the last thing I want to throw up here is in this concept of law, I want to leave you with an image, if I may, of various different legal systems. Because remember, we started off with natural law, customary law, positive law came along, but when positive law superseded and pushed aside customary law and natural law, there needed to be something to temper the injustices of the legal system. And that's where human rights has come in. And now there's a body of thought that what we actually need is these 4 areas of law, that there's a sort of a tension between them, which is necessary for sound legal governance. And it's been, one person has put forward the idea of a picture of a kite in which, you know, each of the 4 points on the edges of the kite holding the kite together are one of these bodies of law. I have a different metaphor for. I see customary law as being the deep flowing water in the river. You know, it's slow moving, and it's evolving very, very slowly, but it evolves to meet local needs and challenges. It gives stability. You know, if you look at your river and you go to the, that's where there's a strong body of water, and it's the lower water. The positive law is like the fast bubbling water on the top of the river. It's always changing with new governments. It's always responding to, you know, a new government comes in, they want to change everything that happened before, and you've got this constant, you know, change for this and change for that and whatever. And it's quite distorting. And without law, we get these massive shifts back and forth, which are very destabilizing. Natural law is like the lake into which the river flows. And natural law's role was to, you know, part of its role was sort of to adjudicate between these 2 different bodies of law, yeah, and where they're in conflict. I was looking at it and I was thinking, and I started off with those 3 aspects, and then I thought, well, if human rights is important, what's human rights look like? And the image I got was the fountain, the big massive fountain that's in Lake Geneva in Sweden, which shoots water up 200 feet into the air. And I thought, that's human rights. It shoots up, and people look at it, and you can look at it and you can see it, and it's powerful and it's nice to look at. But as it's blown by the wind, you know, it's either falling on one part of the lake or another, or it's coming back down on itself. It's not covering everything. And so human rights on its own can't mitigate for all the potential ills of the positive legal system. And so I believe that we do need to recognize customary law and natural law as well. And I'll leave it there for the moment. At the end of isn't it the case that when you ever finish a piece of research, you know, you get there and it's going, you've just got the question for the next bit that you want to go on to, huh? You know, and everything that you've done before has, you know, if you could just narrow it down to that question, and it's sort of, now this is the thing that you want to know. And the thing that I would like to know is, I would like to know more about the legal philosophies that customary legal regimes. And, you know, and what is the legal philosophies underlying early Irish law? And the place that we find that we've got various sources. I mean, obviously we've got this incredible body of
documented early Irish law. Yeah, much of it written down, I believe, in the 17th century, based on materials that would have come earlier. But we have a lot of this. We have a lot of this written down. But remember, I was talking about the fact that when you have when you write down your laws, you're in danger of fossilizing them. What you're actually doing is you're catching them in time, and it's on this particular day the law has been interpreted in a particular way. Huh? Now, if that way is going to be that forever, there is no process for dealing with the way society changes. What's one of the fundamental benefits of a customary legal regime is that if you think of it, if you go to the stories, and Sandy's been taking us through this, and if you go to these Irish myths and the myths of the kings and the nine hostages, wasn't it?
Yeah.
But if you go back to some of these stories, what you will get is you'll get stories, and from those stories you can see what the law was. You have Diarmaid and Gráinne take off together, and they come to a sticky end. And it's like sort of yes, you've got all this romance, but you have this sort of this concept of the law as well in relation to that. Now, because customary law is dynamic, it means that in each particular stage and period in time, it's able to be interpreted in accordance with the mores of the time. And that's the same as we have with the Constitution. That's what we have. But there's much more flexibility when it's not written down. What actually happened with the codification of customary legal regimes was a mechanism by which colonial powers actually froze the legal regime in a status that they were prepared to accept at the time. Now, this is really, really relevant all across Africa and in other places, where basically the colonial power would get into a cozy relationship with local leaders, and they would write the laws in a way which would consolidate the power of that leader of the moment into the future, which of course is what they did when they did away with Tanistry, with the Taoiseach laws in Ireland, because what they were doing is they were putting it into a system which suited the English for tax purposes, and it suited the leader of the day because it meant his line was going to hold the power into the future. And so it was a consolidation of power and wealth. And, in Ireland, the offers, rejected by many, but taken up by quite a few, to swing over and swear fealty to the king and to come under the feudal system, was a way of consolidating the power of the people of the moment. What's interesting, if we go back into early Irish law, is that one of the most significant concepts that was there was the whole place of the role of the king. And, this I'm going to touch on land rights, kings, the responsibility of the kings, and I'm going to touch on women's rights. And it's just to sort of give us an idea. So Ireland was traditionally governed by the Ardri or High King and as many as 150 regional or petty kings. Kelly, who was a leading scholar on early Irish law, has identified numerous references in the law texts, wisdom texts, and sagas to the importance of the king's fear Flahamon. You'll have to forgive me, I haven't done Irish like in 30 years, and then I did it badly. I hope to some stage, now that I'm back in Ireland, to actually take class in it, so please forgive me for this. But the king's justice, and the king's justice was seen as being absolutely necessary for possibilities of peaceful and prosperous times. And so a king guilty of injustice, extortion, or king slaying could be legally overthrown. The unjust king whose rule was seen as causing not merely his own damnation, but a kind of cosmological tragedy. And so there was this whole sense of obligation. They actually sort of, there's talk of a guilty king bringing about infertility in women and cattle, crop failure, dearth of fish, defeat in battle, plagues, lightning, etc. And so there's this pressure on the king. So although you have the king, you know, I suppose in many places people are looking at the king as the, you know, the person of absolute power. Or in terms, it might be interesting in the concept that I know Sandy has been discussing here in relation to the chosen, you know, that it wasn't just you have this situation, you are the chosen, you're the king, and therefore you can do what you like. No, it's actually you have this position of power, but there is a great responsibility which comes with that. And this notion of the unjust king and the obligation to respect and to look after the community was one which were very important in the development of the Irish legal system. There's a question there of this notion of the unjust king, and it became, you know, very strong in the in some of the Christian political texts, legal texts that came out of Ireland. And these then would have been disseminated across Europe. And there's a question about whether precepts of old Irish law may well have influenced notions of kingly justice across Europe, even as far as being found as having been well accepted in the court of Charlemagne, who reputedly said he loved the wandering monks that were coming from Ireland. Penalties for dishonesty of the chief, who stood to lose his honour prize for a wide range of infractions, including the refusal of hospitality, failure to fulfil contractual obligations towards scaling, eating food known to be stolen, tolerating satire, and betraying his honour. And it's really interesting, this, because, you know, you have a situation here where the community is really in control, has this element of control over the behavior of the king and of the chief. And one of the things that came to me when I was looking at this, I raised the question to myself whether in 2008, when Ireland was going through the economic crash, and we watched this situation with those responsible, you know, walking away unscathed and leaving all of the weight on the community at large, that there was no sense of this responsibility. It was like sort of, you know, well, I did this, but I'm not responsible. Whereas quite clearly in early Irish law, there was a real important concept of responsibility. And I put up in the chat, I put up a number of articles. Somebody asked me about the book on Navajo law, and I put that up. And I also put up a reference to the story of the twin heroes. And this was a story that there was a situation of an indigenous leader in the last 10, 15 years or so. I'm not sure if it was Navajo, it may well have been, I think it was. And he was elected into, you know, I suppose what would be the local mayor or whatever. And he was found or considered or believed to be operating in a way which was not to the benefit of the people, but there was no way to get him out of power. But what they did was they went back and they looked at the old stories, and they found in this old story about the twin heroes this concept of a fiduciary duty of a leader to the people as a whole. And they used that in the courts, in the Navajo Supreme Court, they used that in order to find against him and to get him out of power. And, you know, I think that's, so when I talk about looking at Indigenous legal philosophy, I'm talking about looking for principles of responsibility, of this obligation to community. And as I say, we can see this coming out of the law text. So to avoid the dangers of being responsible for injustice, it was the practice of kings to retain a brehon, a judge of the tuatha or kingdom. And a wise king would no doubt have looked for a wise and learned judge. Now, the actual brehons training, that could go on for up to 20 years. And leading brehons were versed in 3 areas of law. There was the féinachas, which is the law of the freemen, the dlí fildeach, or the poetic law, and that's the law preserved in poetry, and the breth lehan, which is canon law. An unjust judge was seen as one of the 3 ruins of a tuatha. So, there were severe penalties for judges, including disgrace and physical punishments. Any brehon who failed to act impartially or who willfully pronounced an unjust decision. I think this is really interesting because under the legal systems that we have now, there is very, very little that can be done when people are in power. There just isn't this same sense of responsibility. Now I want to go on to the next issue, which is women's rights. Sometimes it says, that, the women had, equal rights. They did not have equal rights. The old Irish society was patriarchal, and women were grouped along with children and slaves in the group considered beith, or legally incompetent or senseless. And from this, there comes an old warning of Condartha Cuirbán. The worst bargains are the contracts of women. And this was derived from the general lack of capacity of women to enter into contracts. So if somebody went into a contract with a woman, basically they might not be able to enforce it, because it would say that unless her husband or whoever was her guardian had approved it, then it wouldn't be an enforceable contract. But women's status as dependents was not immutable, and the law recognized legal rights to inherit and divorce in certain cases. It's said that, influenced partially by the church, it was when they wrote the major legal tome, which is the Seanchas Mar, that was women were entitled to conclude independent contracts and to hold a life estate, at least, in their property of their father, if there was no surviving sons. And this is interesting because, although they weren't, equal rights, they went much further than the rights under the common law. And there's also a thing in the Seanchas Mar where there are reference to a female jurist, breed, and meaning high status or privilege. And she appears to deliver judgments on women's issues. And based on that, on one of her judgments, is this notion of the entitlement of daughters to inherit from their fathers where they had no brothers, yeah? Irish living law also gave women rights to divorce that weren't accessible in other European states. And much of the Cain Lanna, one of the principal texts on women's entitlements, deals with division of property at a divorce. So women could divorce for physical violence, leaving a blemish, for adultery, for a husband failing to support her, or for spreading false stories or satire about her. So, this notion of you're entitled to your good name was really important. She was also entitled to divorce if he was impotent, homosexual, indiscreet about their sexual relations, or if he takes holy orders, or he's so fat that he was incapable of intercourse. And so there's a wide range of divorce things that not necessarily all are now still recognized as rights for divorce in these days. In this situation with regards to the rights of women, in 697, the adoption of the Cain of 9, the church tried to portray itself as a champion of women's rights, and so it doubled the price for killing a woman, and it prohibited women from from going into battle. It's not clear how much it actually did improve rights, but by the 8th century, the rights of women was one of 4 principal edicts. Patrick's law, you can not to kill clerics. Admonan's law, not to kill women. Dira's law, not to kill cattle, and the law of Sunday, not to transgress at all thereon. Huh? Now tell me just please here, do I still have a few more minutes or have I run out of time?
Yeah, you have a little bit more time, yeah. Go.
I can't hear you, Sandy.
It's because it's Emma talking.
I can't hear you.
Couple more minutes, Brendan.
All right, great, because I just wanted to touch on land rights.
Yeah, carry on.
Okay, right. I've already mentioned gavelkind and you know how it was done away with. What I want to talk about is again this issue of responsibility, because I think it's so important and it's so crucial for the moment. You know, when we're coming up to the 100th anniversary of 1916, and there was talks about, you know, constitutional change and whatever. You know, I was asking myself, you know, should some of these concepts, can we get some of these concepts into the Constitution? And, you know, one of the lands were held, a lot of land, it wasn't sort of private land, it was held in the Fina, which was that all land belonged to the community rather than to the individual. Private lands could be secured, but they were always sort of circumscribed by an indefeasible nature of the collective ownership of the land within its jurisdiction, you know, by the clan. So a portion of the lands of the clan were set aside for the maintenance of the poor. And it was the responsibility of the king or the chief to look out for all those who lacked guardians. In order to ensure that the most worthy person would come to rule, I've mentioned that, they had the selection of the Taoiseach. But what that did is it gave an opportunity to keep unstable, incompetent, or corrupt individuals out of positions of overriding power. And, you know, if we look back through the history of Roman history as well as our near neighbors' history, we can see that in some cases, you know, following the firstborn led into cases where people who were very unstable came to power, though it seems that there are other ways they can come to power too. The chief only had a life interest in the lands, and Irish law placed a very strict responsibility on families to look after dependents. And one of the 7 fugitives of justice who could not be protected by sanctuary by a nevid or of either God or man was a man or woman who fled from the assistance of a mother or father. Irish law also sought to secure the rights of all inhabitants of the Tuatha to look after their own needs through access to wild foodstuffs and materials as needed to prevent starvation and protect them from the cold and to meet their basic needs. And there's a passage in the law tract, Do Fastad I Dliad, on the confirmation of the right and the law. And it's cited in the Erne fishery case, which I'll touch on just before I finish. And it says, how many things have been established as the inherent rights of every territory and of which are equally due to every person? Question mark. And it answers, the salmon of every place, wild garlic, the andach property of each water, the quick drawing of a net from each stream, the sufficiency for a night of faggots of each wood, cooking fuel in each wood, the mast or nuts of each wood, materials for each carriage, timber for body bearers, a handle for a champion spear, the wild animals of each wood, through which there is passage with necessity, the sea wrack of each strand, the salt leaf of each rock, the produce of each wave outside the rock, grinding upon the whetstone, an acknowledged fair green, going into a boat, playing chess in the house of a chieftain, and then the mountain which overtops it all. Now, over time, what's interesting in the, you know, in the major law tracts is you'll see there's a lot of glossaries where, you know, over time they've added in, and some of these, for instance, they started to restrict that, you know, that somebody could take one salmon, not all the salmon of the place, etc. And I was wrong. I mentioned that it was during the reign of Charles, but it was actually during the reign of James I that the two cases that I mentioned of gavelkind and the Tanis system of succession were overturned. Yeah, the King's Bench in the case of the Tanis case, which went on for 3 years, it held that the custom of tanistry was void in itself and abolished when the common law of England was established. Writing in 1888, Montgomery claimed that it's William Montgomery in A History of Land Tenure in Ireland. He wrote that the result of these decisions, of the gavelkind decision and tanistry, was a grave error was committed and substantial injustice was done. And you know, it's really interesting to see these cases and see you know, this law and the amount of responsibility which was there, which has been lost from a lot of the law today. You know, here we are dealing with issues of homelessness and you know, in terrible situations for many people, and I think we have a lot to learn. I'll finish on this one. In following, you know, Irish independence, there was a brief resurgence of early Irish law, and 300 years after it had been erased by these in the time of James I, in what's slightly ironic historically is that there was a provision in the Magna Carta which limited exclusive fishing rights, and it was applied to an interpretation of Irish law. I'm sorry about that. There's somebody coming in. I'm trying to switch that off. In the first of these cases, there was a number of fisheries cases, and the first of these was the Erne fishery case. And the Supreme Court in that, based on evidence of two of the leading scholars of Old Irish law, MacNeill and Binchy, they decided that exclusive rights were not recognized in Old Irish law, and that a 300-year-old grant of exclusive rights on the Erne tidal waters was void. So here we have, like, sort of 300 years on, there's Old Irish law to overturn these exclusive rights. 10 to 20 years later, in the Moy fishery case, Binchy had changed his opinion. And in that case, the judge found that exclusive fishing rights had in fact existed in early Irish law. And since that time, there really hasn't been any use of law in the modern day Irish courts. But it's interesting that when I presented on this issue at the Irish Centre for Human Rights, there was a senior counsel president who immediately sort of said that, you know, he was interested in the possibility that it might be drawn upon again.